Okay, we will start in 1 more minute.
Okay. Bila kita dah live, you will tell me, right?
Yeah, we already gonna start now.
Okay.
Okay, so all right. Good evening, everyone. I hope everyone is doing well wherever you are right now. And welcome to our seventh episode of the Strata Talk Show. My name is Amiza, and I will be your host for today's Strata Talk Show. And this talk show is brought to you by the Excel Academy of Real Estate. Miss Saraswati Shirkedio will be our guest speaker for tonight's talk show. And for today's episode, we will talk about when can a property manager be held liable for negligent advice or management of strata properties. It's a long topic, right? Okay, so guys, if you have any questions regarding this topic, feel free to type your questions in the Facebook comment box below. And hopefully, we can entertain your questions by the end of the session today. And hi, Miss Sara Deo. How are you doing today?
I'm very good, Amiza. Thank you for the
All right.
introduction. And
Okay.
I'm happy to join you today and Excel Academy. It's a real pleasure and honor to be speaking on this topic,
Okay.
liability of property managers, something that's, I guess, very relevant these days. Yes,
Yes.
Amiza?
Yes, true.
All right.
All right. Good to
Okay.
know that. Okay, so without wasting more time, let's welcome Miss Sara Deo to start the session right now. I pass to
Thank
you.
you, Amiza. Thank you.
Okay.
Hello, viewers. Thank you for joining me today on a Thursday evening to explore, discuss, and have a more interactive session on the subject matter today. And without any further ado, let me take you through the subject matter. And we are talking about negligence of property managers, yeah, specifically. Now, before even I go to how do you establish negligence, how do you sue a property manager for negligence, and how do you defend an action in negligence? If should you be sued, how do you defend an action in negligence? Let me first give you an understanding as to why the law of negligence. Yes. Now, generally, a property manager will sign a property management agreement, some sort of covenant with the management corporation or the joint management body, yeah, the management body, or alternatively with the developer. Now, so the relationship is actually contractual in nature. You sign an agreement, you agree to do something, and you get paid accordingly, according to the terms of the agreement. And should you breach the agreement, then there is a cause of action, okay, for the party who suffers loss to sue you on the contract. Now, today's topic is not so much about contractual liability. Today, we are talking about negligence. Now, then the question will be, what then is negligence? So, negligence is basically outside the contract. Okay, now this is where the law imposes a legal duty on you as a property manager to take care of the management corporation, of all the proprietors, okay, of the management body, to exercise skill, due care, and to conduct your practice in a manner which is compliant with your profession. So the moment you fall short of the standard of care that is required of you, you can be held liable in negligence. Yes. So the law of negligence or liability for negligence is, number one, outside the contract. So it's not a contractual action that we are talking about. It is an action which is outside the contract. And the second question that you need to then consider is, when does liability arise? Now, liability in negligence will arise when the law assumes or the law imposes a legal duty on you as property manager to take care, to exercise due care and skill. Now, the question is, The law will not impose a legal duty on you to take care of everybody under the sun. Yes, I mean, Amiza, I think that will be unfair to expect property managers to care for the condominium next door, or the street outside the development. Yes, so the law is
Yes.
very reasonable. Yes, so the law of tort, it's spelled Tort for those of you who are not from the legal background. Tort means, okay, a civil wrong. All right. And in order for you to establish liability for negligence, there are four elements. Okay. Remember, number one, you need to establish that you owe a duty of care, or rather, it's the other way around, that a duty of care is owed to you. And number two, the person who owes you the duty of care, say in our present situation, the property manager, had breached his duty, meaning he failed to meet the standard of care expected out of a reasonable property manager. So, if a reasonable property manager would have acted in a certain way and you did not act according to that acceptable, reasonable standard, then you can be deemed to have breached your legal duty owed to the other party. Now, the duty of care and the breach alone is not going to establish liability. Now, you need to show, now, because you breach your duty, meaning you fail to meet the standard of care reasonably expected of you as a property manager, you caused harm to another person, meaning the proprietors or the management body. Now, causation there is very important. Now, the chain of causation, there must be no break. That means you must not have an intervening act by a independent third-party contractor, for example. So if you have a break in the chain of causation, then the harm is not caused by you. Then why would the law hold you responsible for anything? Yes, no matter how
Yes.
badly you behaved, yeah, no matter how much you fail to act as a proper property manager, meaning you breach the duty, but if there is no harm caused to anybody, then there is no liability. Yes, so unlike criminal law, sometimes in criminal law there is no reason for any harm to occasion. For example, I give you an example. You park your car on a yellow line, for example. Did anybody actually suffer loss or suffer any kind of damage? Not really. But then again, we have rules, criminal law, which says the moment you park on a yellow line, you've committed a road traffic offense. So a fine will be automatically imposed on you. Now, under the law of tort, this is a civil wrong, remember? So here, there is a requirement for someone to suffer loss, okay? And there is a requirement for you to have caused that person to suffer the loss. So that's the third element, right? So there must be an existence of a duty of care. You must have breached the duty, meaning you failed to act according to the reasonable standard expected out of you. Third, you cause harm to somebody and there is no break in the chain of causation. Now, causation, if I may add, is actually a simple factual inquiry. In law, we actually ask this question: but for the failure of the property manager, would the proprietor suffered the harm, for example? So the test is the but for test. Yeah, so it's a simple factual inquiry. So you look into the facts of the case, the circumstances that's surrounding the incident, and you ask yourself, is there any other reason that can support, or is there any other reason why this person suffered loss? If there's none, then it all points to only one person who committed the breach. Now, that alone is not enough. That's your third element, causation. Now, the last element is the harm that the person suffered must be something that's reasonably foreseeable. Yes, meaning it must not be too remote in law, or it must not be something that the law considers as not reasonably foreseeable, right? So reasonably foreseeable here meaning most of the time it'll be some sort of property damage, okay, that the person suffered, or some sort of physical injury, all right, as a direct result of the breach. Or sometimes it can be monetary loss, but you can't sue for pure economic loss unless there is an assumption of an additional responsibility for economic risk. Yes. So these are the four elements that you need to know, rather, okay, both
Mm-hmm.
ways, whether you are a property manager or whether you are a proprietor or you're a member of the MC, or you're just general member of the public. These are the four elements. So number one, you need to know whether the law imposes a duty of care. Now the question is this: when does the law impose a duty of care? Does this mean the property manager owes a legal duty in law to each and every proprietor? All right. So every time he does something wrong, if let's say that particular condominium has 1,500 proprietors, can all 1,500 proprietors sue this property manager? How does it work?
Mm-hmm.
Now, in law, what we normally do is that in order for you to establish that this property manager owes me a legal duty of care, uh, what you need to prove, all right, in the law of tort is this. Number one, that the property manager can reasonably foresee that if he were to conduct himself in a manner which is not acceptable to reasonable property management standard, then he can cause me harm. He can reasonably foresee that, yeah, or the law can reasonably presume that it's foreseeable. Okay. Second, there must be proximity. So you cannot be made liable to the world at large, right? So that's it. What I'm trying to say is there must be some degree of closeness, all right, between the property manager and the proprietor. All right, there must be some sort of special relationship or some sort of proximity in law to establish or to impose a legal duty on the property manager. Now, third, the court will consider policy considerations, meaning the court will look whether it is actually fair. Is it just? Is it really reasonable to expect the property manager to be liable in law? Because you must understand the contract is between the property manager and the management body. There is no contract individually, okay, with each proprietor, like I said. So in order for us to now go outside the law of contract and impose liability under the law of tort, okay, it is very important to first realize whether it is, or rather first analyze whether it's fair, just, and reasonable to impose a legal liability. Yes. Okay. So to wrap up, to establish liability and negligence, you need duty of care. The duty must be breached. There must be causation. And lastly, you must also prove that the damage suffered is not something that's too remote. Okay?
I
Now,
see.
that is the law of negligence, Amiza. So if I were
Mm-hmm.
to just take you through a little bit in regards to property management per se. Today, property management is a professional field almost. Yes, sometime back, everybody can do property management. There was no regulation or control. Right? Today, property managers are held in, I would say, high esteem. All right, we expect our property managers to show a lot of integrity, a lot of candor, and act in a professional manner. Yes, today, well, the term registered property manager is actually it's defined under the Strata Management Act, Section 2. And Section 2 directs you to the Valuers, Appraisers, Estate Agents and Property Management Act, 1981. We call it the Act 242. Now, if you go to the 1981 Act, Section 2 of the Act actually speaks of what is property management. Now, this is the amendments that was brought about to the 1981 Act, yeah, recently. It actually defines what is property management practice. It defines who is a property manager. And if you look at the scope of property management, yeah, that is actually laid down under Section 22I, sub 2. Okay, and if you look at Section 22I, all right, you will see a list of tasks that's considered as property management practice. And the words that's used here is includes the following. That means Section 22I of the Valuers, Appraisers, Estate Agents, and Property Management Act, Property Managers Act rather, does not limit property management to only A, B, C. It tells you that, well, property management, the scope is these items listed here, and it leaves it open. So you can by reading the words, okay, including the following. So it's a very inclusive provision, meaning property management may extend in future. Now we are going through a pandemic, Amiza. You know about it, and many people live in condominiums. Yes, so
Yes.
you will. It's inevitable that when it comes to property management today, that you will have to manage COVID incidents. You know, because you will have sometimes you might have a cluster, and that's the most serious consequence of this infection. Sometimes you may have one or two families, okay, they are put under quarantine. So as a property manager, what is the scope of your duty? Now, if you strictly look into Section 22I, it doesn't say that you must, make sure that sanitization takes place, or you must do these, must report to authorities or call ambulance or things like that. It's not listed there. But in today's time and place, I think we can assume that that very much falls under the property management or the property manager's duty as well, like making sure that people wear masks. Okay, in common areas, sometimes people feel that, well, I'm in my condo. My condo is my home, so I don't have to wear a mask around. Okay, but if I'm walking outside, it's a public area. Now, well, outside you will get fined, so they will follow. But in the condominium, they will tend to adopt a more relaxed approach. So this is where the function of the property manager comes into place. Yeah, and in enforcing mask and all that, well, I would like to mention this, Amiza. uh, don't be too quick to go and impose fines on proprietors, because you cannot, according to the law, according to the
Mm-hmm.
Strata Management Act and the Strata laws, impose fine for not wearing a mask unless, yes, there is an unless you have adopted a bylaw, right, via a
Okay.
special resolution at the AGM, meaning you had an AGM and you passed a motion, and by way of special resolution you adopted an additional bylaw saying that if people don't wear mask in this development, we're going to impose a fine of, say, 100 ringgit. Yes, so once that additional bylaw is adopted by way of special resolution, it becomes a enforceable bylaw, just like any other bylaw under your third schedule. So then the property manager can help the MC to impose fines. But if you don't have that additional bylaw, then you are only allowed to maybe caution people. You can put up notices, you can educate them, maybe you can encourage people to follow COVID appropriate behaviors, so on and so forth. Yes, okay, so
Yes.
I touched on what is negligence, right? Who are property managers, and I spoke about the scope of property management. And if you remember what I just said, I said the scope of property management is wide. Yes, because the
Okay.
statute is actually widely worded. That's number one. It's very inclusive in nature. And I am proposing or suggesting that even management of COVID incidents in condominium should fall under property managers' responsibility. Yeah, okay, to manage, okay, just to not to get involved in, let's say, issuance of fines and things like that, but in managing, in ensuring proper sanitization is in place, that people are observing COVID appropriate behaviors, so on and so forth. Yes, okay, so
Okay.
that explains the topic in a overall manner today.
Mhm. So, Miss
Yeah.
Sarah, you mentioned just now there are four elements to prove
Yes.
negligence, which
Yes.
are first the legal duty of care
Correct.
and breach of the duty
Correct.
and causations and also the
Causation.
remoteness of
Yes.
damage, right?
Yeah,
So,
that's
in
correct.
terms of property management and the liability of property managers for
Mm-hmm.
negligence advice, which element will be more challenging for claimant to establish?
Very good question. I like this question. Now, the topic today, we are talking about negligent action and negligent advice, correct? Now,
Yes.
negligent action meaning there's a positive act on the part of the property manager, like doing something, yes. But
Okay.
negligent advice can be a situation where the property manager gives a wrong advice
I see.
negligently, okay, to
Okay.
the management committee members, and then the management committee members act on his advice, and then some sort of harm is occasioned either to the management corporation as a whole, or the harm is caused to maybe a group of proprietors, or maybe even a third party for that matter.
I
So the
see.
question
Okay.
is, we want to hold the the property manager liable for the negligent advice. And your question, very beautifully you've put, which of the four elements then becomes more challenging? Yes.
Yes.
Now, in my view, or I would say this, that the first element will be the most challenging, the duty element. Yes.
The
Now I
duty
tell you
element.
why.
Okay.
Yes, the duty. Why? Because if you look at general negligence, okay, we are not looking about negligent misstatement. When we talk about negligent advice, we are talking about where there is a misstatement of advice.
Mm-hmm.
Yes, you've made a negligent advice. So when you're looking at negligent misstatement, negligent advice, what is very important is this: you are going to be made liable for an advice, okay, so you must understand it's very drastic, correct? Okay,
Yes.
it's not like you did something, you never do anything, you are just giving a poor thing, you're just giving an advice, and then you're going to be held responsible in law. So why I say duty of care is because the courts will be very slow to impose a duty in situations like this. Now, the court will say, in order for the plaintiff to say that the property manager ought to be made liable for his advice, then there must be some sort of assumption of responsibility on the part of the property manager. I give you an example. So, if
Okay.
let's say the MC is planning to carry out some upgrading of the swimming pool, and then this Mr. Yo, let's call him, right? Mr. Yo now wants to, or rather, Mr. Yo is the property manager. Mr. Yo goes and volunteers advice to the MC. So Mr. Yo then says, hey, look, MC, don't worry about the upgrading of the swimming pool. I think everything is fine. The water leakage, don't worry. We will just put some sort of coating or whatever. And then we will try to, stretch the time a little bit because we are running out of funds. Instead of repairing the water leakage at the swimming pool or upgrading, why don't we just install more CCTVs? Because I think that's important. And then the
Mm-hmm.
MC asks, hey, are you sure or not? Okay, have you obtained any kind of advice? Then the property manager here, Mr. Yo, he holds himself out. Don't worry, I've checked. Okay, I've checked with so many architects or engineers or
Mm-hmm.
some professionals. I know I manage many condos. I'm the king of property management in Klang Valley. I know everything. I'm well connected. A lot of property managers use words like that. So you hold yourself out, correct?
I see.
So
Yes.
what I'm saying is, Amiza, in situations like this, that property manager has assumed an additional responsibility. So in
I
situations
see.
like that, the MC will place reliance, correct? Because
Yes.
you are telling them, you're holding yourself out as some sort of specialist or expert,
Mm-hmm.
and like as though you've done some special research. So the MC will place reliance on your advice. So the MC, most MC members are experts in different areas. They may not know property management. So in this situation where there is assumption of responsibility on the part of the defendant, meaning the property manager, and there is also reliance placed on his advice. So these two together creates a special relationship. So only when there is a special relationship, a peculiar circumstance like this, will the court be willing to impose liability for negligent advice. Otherwise, the courts will be a little slow to hold you responsible for negligent advice.
I see.
I hope
So,
it answers your question.
yeah. So I have another question, which is like, from your observation, are there a rise in litigation against property managers for negligence act or negligent advice?
Okay.
Yes.
Um, you are asking me, is there a rise in litigation? Is it?
Yeah, litigation.
Okay. Uh, I think yes. Okay. Simply because we find um, many recent cases.
Okay.
Not every case is successful in establishing liability, because most of the time the court did not impose liability on the property manager. That is not because property managers cannot be sued in negligence. Yeah, it is more
Okay.
because some, like for example, I give you a recent case. We have this case called residency. Okay,
All right.
very recently decided. Do I have the citation? I don't have the citation, but it's decided in 2021 recently. And here, the property manager was cited as the second respondent, or rather, the second defendant in that action. And the
Okay.
court did not impose liability simply because there were other reasons. Like, for example, the plaintiff's pleadings, the pleaded case and what the plaintiff actually sought to prove at the trial were two different things. So if you read the judgment of Dua residency, you will find that for the most part, the court was talking about this rule in law that you are bound by your pleading. So if you go to court and you say, you allege, okay, you
Okay.
plead in your pleadings, yeah, you're bound by your pleadings. So you tak boleh, you cannot go out of your pleadings, because if you do that, there is an element of surprise. You're not being fair to your
Hmm.
opponent. So, because of those reasons, in Dua residency, the court did not find the property manager liable in negligence. But your question is there a rise as far as litigation is concerned? The answer to that is yes, because recently there are many cases where the property manager has been cited as a party,
I
whether
see.
the property manager is cited as normally as a second respondent, right? Normally the management corporation is cited as the main defendant, and the
Okay.
property manager as a second defendant. Sometimes the property manager is cited alone, okay, for his actions as well. Now, this is where the management corporation is suing the property manager. So, whether it is at the tribunal or whether it is at the civil courts, the observation that I make is that yes, people are more aware of their rights now, and that is probably because we have very benevolent NGOs like the National Home Buyers Association, and then we have, of course, we have seminars like this where people
Yeah,
can attend, and people get educated, people understand their rights, their responsibilities. So people are becoming more and more aware of their duties, the responsibilities, and their rights. So because of that, I think people are more, I won't say litigious these days, but more willing to exercise their legal rights.
I see. Okay. So,
Yeah.
Miss Sarah, before I like your example just now. So before we proceed to the Q&A session, there's a
Mm-hmm.
last question from me. So,
Mm-hmm.
what are the preventive measure that
Mm-hmm.
property managers can take to avoid liability in negligence? Yes.
I can answer this question in one line, or
Okay.
I can answer it in 15 minutes, but I'll give you the easier
Okay.
answer. In
Okay.
order to avoid liability in any profession for that matter, Amiza, I think whether you are
Okay.
a lawyer, doctor, or whatever, I think as long as you act according to the reasonably expected standard of care of that
All
profession,
right.
that means you meet the standard that
Okay.
your profession imposes on you. So, for example, if you're a property manager, right, you act with due skill, due care, all right?
Mm-hmm.
Take all reasonable precautions, all right? Be honest, okay? Have candor, be transparent in what you do. Don't be sneaky. I know people are not, how do I put it? People are aware when you try to conceal facts, you try to mislead, you will eventually get caught. So try to
Yes.
avoid all these practices, try not to manipulate invoices, try not to have a cartel of yours. You have one list of contractors and whatnot, you bring them to the condo and try to engage them, and then you tell them, oh, mark up the prices. Don't do that. Of course, you
Yes.
see, in a strata setting, right, Amiza, I mean, I'm sure you know this, that the property manager will have a good contact of who are the best contractors, for example, who are the
Yes.
best chargemen, who can actually repair leaking problems and things like that. Now, that's acceptable as long as there is disclosure. So even if you say, for example, a property manager recommends a legal practitioner, for example, even me, for example, I work with a lot of property managers, yes, because sometimes these property managers, they seek my advice, and then when
Okay.
the MC also wants to obtain some sort of legal advice, they will ask the MC to engage me. Then the MC, of course, when the property manager is doing that, there will be full and frank disclosure to the MC. Look, I know Miss So and So, and she practices strata management, so you can seek her advice. Or, for example, I know this contractor. We have worked together in a different development. I recommend this contractor to you, but then you decide. So ultimately, there is full and frank disclosure, and make sure there is no pecuniary interest. That's most important. You cannot introduce a particular contractor to the development, and then every time you introduce a contractor, you get a cut. You get 5% out of the contract and things like that. Then you are committing something seriously wrong, because there is a pecuniary interest in what you are doing. Okay,
Okay.
so to answer your question, I think in order to avoid liability, be very transparent. If you have a contact that you are introducing, be honest about it, and you inform the MC. So later they can't turn around and say, oh, we never knew, but then we found out. That's wrong. But if you tell them upfront, that's fine. Okay, but you've made the disclosure. And similarly, when you are making decision, when you're giving advice, if you are a property manager, you stick to property management. You don't go and talk about civil engineering, for example. Yeah, because that's a
Yeah.
specialty altogether. So you don't go and give advice on the structural integrity of the building when you don't know. You cannot test whether it's actually, you can't prepare a report, you can't test, you can't verify, so you don't make advice. Or similarly, legal
Yes.
advice, of course, if it is in relation to Strata Management Act, assuming that you can just read, and understand. Even if you find that even the Strata Management Act, I mean, well, the Strata Management Act is a straightforward act of parliament, correct? Okay, it is
Yes.
supposed to be a social legislation, but sometimes the interpretation of the Strata Management Act may require a little bit of legal expertise. So if you are not sure, seek advice. Okay, don't go and give legal advice or talk about civil engineering or architecture and things like that when it is not within your expertise. So if you avoid things like that, I think property managers will not be, subjected to civil suits and things like that.
All right. Okay. Very well explained, Miss Sarah. Thank you.
Thank you.
So right now we are moving to our Q&A session.
Okay.
As I can see here, there are few questions coming from our participants tonight. So maybe you
Mhm.
can choose any questions that
Okay,
you want.
I see a question from, may I read out the name of the participant?
Yes.
Yes,
Yes.
this is Miss Jenny Yo. And
Mm-hmm.
her question is this. I read out the question. If
Okay.
the chairman of the management committee takes on the role of a property management without being appointed by the MC and no accountability by the chairman in regards to the accounts when owners ask, what can the owners do, as he also ignored COB's instruction? Okay, she's narrated the facts a little bit. So I think what she wants to know is that, can the chairman of a management corporation uh, act as a property manager? Well, the answer to that is obviously no. Why? Because, okay, let me explain the role of a management committee. The management committee, the powers of the management committee is derived, of course, from the Strata Management Act. So we are looking at Section 56 read together with Section 59. So to say that management committee will not be involved in any kind of property management is also wrong, because if you look at Section 59, sub 1, sub 2, it talks about management of property. But then what is the role of this management committee here? They are functioning as a management committee, so they are supposed to be accountable, be transparent, be very honest in what they do, and they are actually acting as trustees. Okay, very important, as trustees of the management corporation, meaning as a fiduciary. Now, if you are a fiduciary of the management corporation, you are not supposed to do any of this, assuming that what Miss Jenny is saying, all this has been proven factually. Obviously, this chairman has committed some civil wrong, okay, because he is not supposed to not be accountable. He is not supposed to, you see, it also says without being appointed by the MC. So it's self appointment. That means this chairman appointed himself as a property manager. I don't know whether there is remuneration now paid to this chairman. Okay, if there is, then that also will invite some sort of legal trouble. Yeah. So I
I
hope that
see.
answers Miss Jenny. Well, her question is, what can we do? Of course, you can write to the COB. The COB will then issue a standard letter to the chairman. And for the most part, I think sometimes the sad thing is some of these chairmen and some of these people who abuse powers are very, how to say, they can actually ignore the COB's letter. They do nothing about it. And as owners, you will feel very frustrated because there is no avenue for you to move forward. You can take the chairman to the tribunal, maybe if you want to, because that's a cheaper option for you to take action. Alternatively, what you can do is call for an EGM, have enough support to call for an EGM, and see whether you can overthrow the committee or particularly this particular chairperson. And if that is not doable, then wait for the AGM. Exercise your voting rights. Most importantly, you must attend the general meeting, and then maybe you want to raise this at the general meeting and see what the majority says. If the majority is happy with this chairperson doing whatever they are doing, then I guess you fall within the minority category. That unless your rights are affected directly, then unless your rights are affected directly, you can't do much because the majority is in support of this kind of practice. Yes.
I see. All right. I hope it answered the question just now. Okay.
Uh-huh.
So there are a few more questions. Maybe you can choose any questions that you would like to answer
Okay, there
from our
is another.
participant.
I think I would consider this a follow-up question. Yeah, he says. Well, I think he's answering Jenny as well. He said conflict of interest by chairman, not registered manager, approved by the board of valuers, estate agent, and property manager, and he makes reference to Jenny Yeo. This is
Yes.
by spring that time. Yeah. Now, yes, it is a conflict of interest, as I mentioned earlier. But to say that MC members cannot take part in maintenance and management of the common property is incorrect, because although they are not registered with the board, they can exercise functions because they do have duties and rights and what do you call these powers, okay, under the Strata Management Act, Section 59. But like I said, if they are paying themselves a remuneration, they're taking a fee from the management corporation, then they are acting as a paid property manager. Then that is definitely a big no-no, because first of all property managers are now required to be registered, okay, under the board. All right, there is a registration requirement. Not only you must be registered, you must also obtain an authority to practice. meaning the board must give you an authority to practice, authorizing you to practice property management. Authority to practice can only be given to you provided you practice through a firm. So now even your firm must be registered as a property manager. Now, these many people don't understand. Sometimes you will have the individual registered as a property manager, but the firm is not registered. Then in situations like that, authority to practice cannot be given to that particular property manager. Yes. Now, in situations like this person is now considered a non-registered property manager. Does this mean this person cannot practice property management at all? No, because if you look at regulation 32, all right, of the Strata Management, Maintenance and Management Regulation 2015, it says if you are not a registered property manager, you're not registered with the board, then you are expected to furnish a bond. Yes. So, and the amount of the bond is actually provided in the regulation itself. You must either give 12 months of your professional fee, okay, or 50,000 ringgit, whichever is more. Okay, so if I'm being paid, let's say 10,000 a month, then it's 10,000 times 12 months. I'm supposed to get a bank, go and give a bond, meaning I need to lodge this bond with the management corporation. And the purpose of this is simply this, okay, because when you lodge a bond with the management corporation, this is to give some sort of protection or security to the management corporation, because you are not a registered property manager, remember that, right? So to protect the interests of the management corporation, this bond is there. So in the event you run away with the money, all right, or you siphon the management account or the sinking fund, at least there's some security there. All right. So that is to answer, not to answer, to add to the comment there, right?
Yes.
On chairman acting as a property manager and also being paid. Okay, a simple answer to this is no, because if you are a chairman, you stick to your committee duties, all right, under the strata management. Employ a separate property manager, all right, and choose a property manager who is registered and authorized to practice. But if the person is not registered, you still want to go with that non-registered property manager, at least uh, s- uh, uh, get the bond, as a safety net, okay, to protect the interests of the management body. Yes.
Yes.
Okay. Amiza,
Okay.
can I ask another question?
Yes. There's some question here from. Do you want me to pick for you to choose for you?
No. Can you
Uh,
can
I can choose for you. Yeah? All right.
yeah, sure.
So there's one from Nur Amira Nazaruddin. What are the major defenses to negligence?
Okay.
Yeah,
What are the major defenses? Wait, let me see. Nor Amira. Okay. All right. Okay.
Nazaruddin.
Major defenses. Yeah. Okay. Two defenses that I can think of, which will apply in a property management scenario. Number one is contributory negligence. Okay, this is where the property manager is being sued for negligence, but then the MC members were also negligent. All right, and therefore, what the property manager can plead is that you were equally contributory, or rather, you contributed, okay, to this whole fiasco, whatever you want to call it, and therefore the liability must be apportioned. Yes. Now, contributory negligence is only a partial defense, Amiza, because it doesn't absorb liability 100%. Just
Okay.
because another person contributed and was equally negligent, or maybe less negligent, more negligent than you, doesn't mean your liability goes away. So it's not a complete defense, it's a partial defense. Yes. The next one is assumption of risk. To put it in a simple English, assumption of risk is where it's something like, without sounding rude, it's something like you asked for it. Okay, where
Okay.
where the plaintiff did something that can harm himself or herself. Like, for
Yes.
example, you don't know how to swim, but then you go to the pool, you go to the part which is the deepest part, and then you want to try your swimming skills. Okay, so
Mm-hmm.
you have there, by doing that, assumed some sort of risk. So if should something happen, you want to sue the property manager for not providing you proper safety floats, or not having a lifeguard, and or nobody came to your rescue. But then you must also understand, you yourself assumed that risk. Some sort of, like, saying like, you asked for it. Yeah, so that is also a defense. And depending on the degree of blameworthiness in your action, depending on how blameworthy your actions are, um, the liability will be reduced accordingly, sometimes maybe completely. So assumption of risk can sometimes be a complete defense, sometimes only a partial defense. But contributory negligence, remember this, because the word is contributory. So
Yes.
just because somebody contributed, it doesn't mean you are not liable at all. Maybe the liability will be a portion. So if the court awards 100,000, you will be made liable for 50K, and then the other person pay 50K. All right, so it
Mm-hmm.
goes like that. So those are the two major defenses. But I feel, um, apart from defenses, as far as liability and negligence is concerned, the main challenge, these are not defenses, but these are like, the hurdle, I would say, in proving
Mm-hmm.
liability. First of all, you will find it that very difficult, not to say difficult, how to say, you will find it a little challenging to prove duty of care, breach of duty, causation, and then
Mm-hmm.
remoteness of damage. So that in itself is already some sort of a hurdle for you to cross before you get to the liability part.
I see. Okay, thank you, Miss Radio.
No
So
worries.
let's moving on to the next questions. Maybe we can choose from the
Okay,
Fatiha
I'll pick a
Atira.
question.
Oh, okay, you pick a question, right?
I'll pick a question now. Okay. All right. This is from TF Tan. TF Tan asks, what
Okay.
kinds of things count as negligent in property management? Okay, I think he wants to know scenarios, okay, of
Yes.
what can amount to negligent. Very good question, Mr. Tan. Okay, I'll give you an example. A good example will be what Amiza asked me earlier. If you give a negligent advice, okay, now
Mm-hmm.
if the advice causes harm to somebody who relied on your advice, and in giving the advice you've assumed some sort of special responsibility, then that is a scenario. All right, so that counts as a negligent misstatement, and that can occasion in liability negligence. Another thing that I can think of is, for example, you have defaulters in condominiums.
Yes.
So, as a property manager, you are supposed to advise your MC on the recovery of debts, correct? Now, the
Yes.
Strata Management Act gives provisions for recovery of debts. That means maintenance charges are outstanding, not being paid. First thing first is that the property manager must advise the MC to issue a written notice of demand. All right, because section 78 says there must be a written notice of demand. You must give them enough notice, nothing less than 14 days, right? 2 weeks and all that. Now, uh, and in doing that, there are provisions that you must observe, because if you look at section 78, you must read it in conjunction with um, Regulation 31 of the Strata Management, Maintenance and Management Regulation 2015. Because if you look at Regulation 31 says the written notice of demand must be in Form 20. Yes. So if, let's say, in advising the MC, the property manager fails to mention that, and the MC did not issue a written notice, and then the MC files an action against the defaulter in court, and the defaulter now applies to say strike out, because the defaulter claims, hey, there is no written demand, so you are not entitled to come and enforce these rights on me right now. Or
Yes.
even if you take it to the Strata Management Tribunal, the president will ask you, oh, where is your Form 20? And then the management committee members will look into at the property manager, and the property manager will be like, okay, I don't know. And if it's just one case, that's fine, okay? But what if you go to the Strata Management Tribunal with 20 files, and then all 20 files, are struck out because the procedural requirement is not met? That means there's no written notice of demand, there is no Form 20. And then even if there is a Form 20, you fail to advise your MC how to serve the Form 20. Because if you look at the Strata Management Act, it doesn't talk about the service, yes, the act,
Yes.
the main act.
Mm.
But if you look at the Management Tribunal Regulation 2015, there is a provision that tells you how to serve, or rather how to properly serve documents. Yes, so it says you must either serve personally or via registered post, or even email service is acceptable. Yeah, there is a provision that allows you to do that. Or if, let's say, the defaulter does not want to take service, you leave it, attach it to somewhere close to the property. I normally advise my client, take a picture where you leave it, so at least you have some proof to show that you've attempted service. Now, if the property
Yes.
manager fails to advise the MC, that means the service is actually defective, and then your claim gets thrown out. So if it happens once, it's okay. But if it continuously happens, then the property manager ought to be held responsible for the losses that the MC is suffering, for not properly recovering the debts, of the management corporation, right? So that's the second scenario. Third scenario, I mean, I can go on and on, but I'll give you another scenario, where the
Yes.
property manager can be liable in negligence, where, let's say, there is a proprietor who brings up a complaint about interfloor leakage. Yes, now
Okay.
there are procedures that the property manager must take. Yes, you must issue a certificate to confirm the leak, the leakage. And then after
Yes.
that, there is a presumption under the act, okay, that the top owner ought to make good the repair. But then before you go to actually claim from the owner of the top floor, you need to take certain procedural measures. And if you fail to do that, that is also negligence. If, let's say, there was a special request for advice, okay, from you, and then, or alternatively, you've assumed responsibility, you've told the particular proprietor, don't worry, I will take care of this, and then you fail to take care of it, then these are situations where you can be held liable. Third, or rather now fourth example is where, let's say, a proprietor comes to you and tells you that my lot, okay, is subjected to safety risk, for example. And well, it can be anything. Sometimes it can be a falling object, sometimes it can be a fire hazard, right?
Yes.
Sometimes it can be some sort of structural problem, okay, with the building itself. And if you, as a property manager, what you are supposed to do is to inform the MC to do the right thing, meaning take the necessary measure to avert the safety risk, because nobody wants to stay in an unsafe area. And if you are a property manager of good standing, you will understand that safety risk must be given priority in terms of maintenance and management. What you must do is do the necessary, do the needful. To, if it's a water leakage, then better make sure that something is done to control. All right, so where you fail to take action, all right, or where you give advice which is either misleading, worse still, where your advice is wrong, then these are the situations where you can be held liable in negligence. Yes, so that answers Mr. Tan's question,
Yes,
right?
very good example, Miss Sarah. Okay, maybe we have another 7 minutes. Maybe you want to answer any last question from our participants
Okay,
today?
let me try and take as many questions as possible. Yeah, and let's pick.
Okay.
Okay, I have. Okay, um, this is by Tan Chai Liang.
All
The,
right.
the issue is this issue of illegal stall on common property. Number one, local council has demolished illegal stalls on common property in 2011. Number two, after demolition, developer has built temporary stalls to relocate the illegal traders. Number three, one illegal trader was offered temporary stall further away, but he refused to move out. That means he's still in the illegal space, I guess, the
Yes.
unauthorized space. Instead, he rebuilt the illegal stall on the same location of the common property and continued to operate the stall without permission. Okay. And number four, the property manager is a subsidiary of the developer. And can the property manager now be liable for their action and failure to maintain the common property free of illegal stall? Okay, now if I were to summarize this question for you, there are unauthorized illegal structures being maintained at the common property. Of course, now
Okay.
this becomes directly under the purview of the property manager, correct? If you are the property
Yes.
manager, you must make sure that the common property is not used for any kind of illegal activities, or you must make sure that, if there are any illegal structures, and by illegal structures, we are saying that it perhaps offends the Street Drainage and Building Act. Yes, because any structure that's built must be approved by the local authority. If it is not approved and duly given the necessary consent by the local authority, then you're offending the act. Now, in situations like that, the structure itself is considered illegal. So if that's the case, what the property manager ought to do is to advise the MC, or rather the JMC, I think in this situation is a developer, right? So advise the developer to take the necessary steps to avert the risk, and perhaps follow the instructions given by the local authority. Now, even in an MC JMC situation, any legal notices that you get from local authorities in regards to illegal structures maintained without authority and things like that, you
Yes.
must obey the notices. Okay, that is
Mm.
a legal requirement. It's legal. It is actually incumbent on the property manager and the MC to take action, a positive action. If you don't take action, that means you are condoning the illegality. You cannot do things like that. So in situations like this, I think try a softer approach by talking to the developer, perhaps write a notice, and then copy the local authority so that they are put on notice as well that this particular structure is still there. If nothing works, okay, if you can't solve this by talking, by discussion and things like that, then perhaps you can take an action against them. Because and when you are taking an action, when I say taking an action, it's either the MC, the residents representatives. Perhaps you can write to the developer first, okay, before you go and file an action. But if nothing happens, then perhaps you can sue, because this can also be considered as nuisance. Yes,
I
and
see.
anything that is built on a common property, you must get unanimous approval from all the proprietors. Okay, that's something that that needs to be ventilated at the AGM or the general meetings. So I hope Ms. Tan Chai Liang's problem can be addressed. Yeah, but start writing. I think some legal letters need to be issued, and then perhaps go back to the same local authority, lodge another report, and if nothing works, then take it to the general meeting and see what you can do.
All right.
Do I
Thank you
still
so
have
much, Miss
time for
Sarah.
any other questions? No, right?
We have another 3 minutes,
Okay.
maybe.
Okay.
All
Let
right.
me
So
see.
maybe you can choose any one last question.
Okay, we take a short one. Um,
Okay.
okay. Um, okay. We have. Okay, Miss Sarah, is there an adopted regulation or rather law on conflict of interest? If there is, wouldn't it be easy to penalize anyone who commits an offense? This is by Jai Ganesh.
Yes.
Okay, to answer Jai Ganesha's question, first of all, there is no regulation or an act of parliament that talks about conflict of interest. Now, even under the strata management laws, okay, when we look at conflict of interest, what amounts to conflict of interest, we normally go back to the guidelines given by KPKT. And the KPKT has given a couple of guidelines what can amount to logically to conflict of interest, but that's just a guideline. Yes. Now, in law, however, when we speak of conflict of interest, we look at things like pecuniary interest. Are you profiting, okay, in that relationship? If you're making money out of it, then that is a conflict of interest. All right. Second thing, are you concealing the relationship or the proximity from the MC members, from the proprietors? If you are, then there is a conflict of interest. But if you make a full and frank disclosure, meaning you come out clean, you say that, look, yes, I'm recommending this person, I'm recommending this company. Well, these are all the companies that I've recommended. You are entitled to choose. Okay, that is not really a conflict of situation kind of a thing. Yeah, because sometimes I think what we need to understand is that conflict of interest is there to prevent the management body's funds being taken advantage of. You know, like you can't have an MC member sitting there and then the MC member has a security company. That particular security company is given the contract in the same development. That is a clear-cut conflict of interest. But that said, I have seen, okay, in practice, sometimes uh, that particular person actually goes to the MC and tells all the MC member, look, we have so many other companies, all right, and this is my family's company. You want to consider, you may consider. I'm not going to get a cut or discount or anything, I mean, I'm not going to benefit financially out of this. But if you still want to go with this particular company, let me make a full and frank disclosure. It belongs to my family. And if the MC still wants to accept or award the contract to that particular company, and maybe, you know, make a mention to the general body as well, in the sense that let the other owners know about it. If no proprietors actually object to that, then I trust in a social living, that's fine. Okay, we are not going to be so, like, you know, it's not like a strict no kind of a thing. Okay, but I think the point that I'm trying to make is that the full and frank disclosure and consent from who? From the MC and also all the other proprietors. If everybody is okay with it, I think it is okay, because sometimes when the company is related to someone, you a higher expectation is imposed on you to perform. Okay, so those kind of things. But to answer Jai Ganesha's question, is there like an act of parliament that talks about conflict of interest? No, we fall back on the general principles of equity, common law. As far as the KPKT is concerned, yes, there are guidelines that they have given. So try your very best to adhere to the guidelines. But sometimes, if you find that one or two of guidelines you can't observe, then make full and frank disclosure to safeguard the management body. Right? Thanks,
All right.
Amiza.
Okay, thank you so much, Miss Sara Deo. I hope that I think that's all for tonight. Since we don't have that much time, for the question that we didn't manage to answer, we will answer in the comment sections or on the next episode. So thank you everyone for joining our talk show tonight. I hope Miss Sara Deo answered all your questions, and I hope that everyone have a clear view on this topic. So before I end this session, I would like to invite everyone to join our upcoming seminar, which is on the 25th January 2022, next year, with the topic of when can a property manager be held liable for negligence advice or management of strata properties by Ms. Sara Deo as well. All right. So if you're interested to join the seminar, you can contact our number as stated below 017-856-2228, and you can register with us. So that's the end of our session for tonight. Thank you, Miss Sarah, and thank you, everyone. Have a good night.
Thank
All
you,
right.
Amiza.
Okay, thank you. Good night.